Thank you for coming today. Welcome to the panel on Diversifying Our Courts. I'm Caroline Fredrickson. I'm the Executive Director of the American Constitution Society, and I would say the new Executive Director, but now it's been 3 weeks, so I feel like I've been in the job for years already. It's a wonderful place to be. This is a wonderful place to be today because this is a very important discussion that I think we all had wished had taken place several weeks ago more directly as a national conversation. We're hoping that this panel will help spark that conversation and keep it going. Because this panel is going to focus on the question, what is the importance and effect of diversity on our justice system, and more specifically, on our courts? In the wake of the Senate hearings regarding the nomination of the first Latina to be on the Supreme Court, we ask, what is the relevance of background to judicial decision-making? Should increased racial, ethnic, and gender diversity on our courts be a goal? Does empirical research indicate differences between more and less diverse courts? And if so, in what ways? And what is the importance of gender diversity versus racial diversity? What is the importance of diversity of employment background, public defenders, public interest lawyers, criminal defense lawyers? And what does this conversation indicate about the nature of judging? Are judges supposed to be umpires? Can they be umpires? And were the Sotomayor confirmation hearings a lost opportunity to talk about diversity on the courts? So with that, I will turn it over to our wonderful panel. I will briefly name the panelists, but I will leave it to our moderator, David Savage, with the Los Angeles Times, to introduce them more completely. On our panel today are Sherilyn Ifill, who is a professor of law at the University of Maryland School of Law. And I would like to say Sherilyn actually really helped make sure this panel happened, so she deserves a special credit. Applause in the back, I see, for Sherilyn. Well-deserved, well-deserved. We also have Sylvia Lazos, who is the Justice Myron Leavitt Professor of Law at the William S. Boyd School of Law at the University of Nevada in Las Vegas. And Chiara Torres-Spelisi, who is the counsel at the Brennan Center for Justice, and Judge Theodore McKee, who is on the U.S. Court of Appeals for the Third Circuit. And so with that, I turn it over to David Savage and look forward to a very exciting panel discussion.
Thanks, Carolyn. As Carolyn said, we're here as a substitute for the Senate Judiciary Committee today. It's, I should say, initially, it's nice to go anywhere in Washington in August and find that other people are in the office as well. I always feel like I walk down the street and everybody else has left town on vacation and we're still here working. This is a very timely topic, of course, because by the end of the week, we will have the first Latina justice on the Supreme Court, the third woman justice in the court's history. For the Democrats and liberals in the audience, I should say that one interesting trivia fact is this will be the first time in 34 years that the 9-member court has had more than 2 Republican appointees. It's been that long. Since 1975, there's always been 7 or more Republicans on the court. I think all of you followed the Judiciary Committee hearings. I assume you did a couple weeks ago. I had to sit through most of them. And you would have thought that Sonia Sotomayor being the first Latina justice, that there would have been a lively and interesting back-and-forth discussion about what she will bring to the court with a Puerto Rican heritage, a woman having grown up in the housing projects in the Bronx. But it was very clear from the opening round of statements that from the point of view of the Republican senators, any discussion of her diverse background, they treated that as a sign that she couldn't be an impartial justice and that she would rule based on her personal prejudices and biases. And, there were a whole lot of those questions that said, Judge, I want to be assured that you're not going to indulge your personal preferences and you're going to follow the law. Of course, she knew what the right answer was. You say, I'm going to follow the law, Senator. I would like to, if I live long enough, to have some nominee say, no, Senator, frankly, I'm going to indulge my my personal biases, and I'm going to ignore the law whenever possible. But anyway, she gave exactly the right answer, the answer you have to give, and so there was almost no true discussion about how her background might affect her thinking, her judging, her view on the court. And so, as I say, we're subbing for the Judiciary Committee today for the next hour or so, and we are lucky to have four panelists here who have thought about this subject, written about it, done research on diversity on the courts. And I think the way we're going to proceed is each of them is going to give a 5-minute talk or so on either what they want to say about this subject or some of the work they've done. Then we're going to have some questions, and then I'm particularly interested in all of you having questions to kick around this topic. I was struck by, I want to read one quote to you. I thought this was interesting. It says, America has a deeply confused image of itself that is in perpetual tension. We are a nation that takes pride in our ethnic diversity, recognizing its importance in shaping our society and adding richness to its existence, yet we simultaneously insist that we can and must function and live in a race and color-blind way that ignores these very differences. Many of us struggle with this tension. Do you know that phrase? That was Sonia Sotomayor at Berkeley in 2001. It's the speech that all of you may have heard about for other reasons, because that was the speech where she made the wise Latina comment. But she herself has a series of interesting thoughts on this. She sort of struggled with this issue as to how race and ethnicity does or does not affect her role as a judge. So anyway, we want to try to talk about why diversity is important and how so specifically as a judge. I think we're going to have Judge McKee perhaps go first.
I feel like we should switch seats. With the risk of embarrassing one of the folks in the audience, someone whom I have respected for years as a fellow jurist and as a scholar and activist, retired Judge Nathaniel Jones. Nate, I feel like we should switch places here. Well, that's probably as much intimidation as I'll face during the entire month of August. So I'm honored that you're here in any event. But let me just start by acclimating, and at the risk of offending you by speaking down to you, which I don't mean to do. But I think if you understand what we do to decide cases, this becomes a no-brainer. The issue is not the importance of, or is diversity important? The question should really be, how in the world could you conclude anything other than the fact that diversity is important? I think that it's fair to say that for 95% of the cases that we decide, any judge on my court or any other court would come out exactly the same way. I remember early on the court when I got my sitting list and I was looking at it, and I saw I had 1 week with the judges, the two of the judges that I identified as being the most conservative judges on that court. I went home, I told my wife, it's going to be a very, very long week, and my guess is I'm going to have a lot of dissents coming out of it. At the end of that week, all three of us had agreed on every single case that we had heard argued. Now, there were no Title VII cases or hot-button cases on there, which may be why, but for 95% of the case is controlled by precedent or by statute, and there's really no issue about it. But those other 5% of the cases have to get decided somehow. And they get decided not through an exercise of bias or, I won't use the phrase judicial activism because I hate that phrase. It's like fingernails across the blackboard when I hear it. But what you do is you analyze the facts and apply legal principles to those facts through some kind of lens. It's the only way you can do it. And that lens is going to some extent, filter your analysis based upon your own personal background. And the way I usually see it is in Title VII cases and summary judgment. It's not all that uncommon within that 5% of cases where this happens, where either my female colleagues, or I have no black colleagues, that's soon to change, but I did, the colleague that I used to have would see a case very differently in terms of whether or not a reasonable juror could conclude that there's a genuine issue of material fact about whether or not race or gender was driving this employment decision. Because in this day and age, employment decisions, no one sits around and uses the N-word. There's not an overt manifestation of racism. And I would submit to you that the problem is that all of us have biases that we're just not aware of. We're bombarded with images from the day we are born. We get it on television. We get it in the music. We get it every time we open a book or a magazine article. And I recall, and I was thinking about this yesterday, the doll experiments that were brought up in Brown versus Board of Education, where even young black kids by the age of 5, when they're given a black doll and a white doll and asked to identify the doll which is prettiest to them, they'd pick the white doll. And I read recently where that experiment was duplicated by someone. I didn't read that much about it. I think in Mount Vernon, New York, and the same results held true, that the young black kids were identifying the white doll as being prettier and having better qualities. So all of us have those kinds of biases within ourselves. So for us to joke to the public or to ourselves and say that we can decide cases based upon total objectivity, if someone really believes that, I would submit, who's a judge, they're either lying to themselves or lying to the audience, and I don't want to castigate aspersions on anyone because I have a lot of respect for people who have said that, but there's some circumstances where you have to say that. But it's a very naive position to take. We have biases that we're not aware of, so how in the world can we say that those biases don't affect our judgments? We try as judges not to let that happen, but it happens, and I think it happens in ways we're not aware of many times. The extent to which we value in a criminal case, the extent to which we're able to identify with the defendant's background in a Fourth Amendment stop and search case. Is it reasonable for the defendant to be able to turn and walk away, or would a reasonable person in that position believe that he or she had no option but to stop, and therefore you get an arrest? Those things turn upon cultural sensitivity, and you have to have in that discussion that occurs after argument, where there's just the panel of judges sitting around discussing the facts and the law, you have to have more, I would submit to you, than the predominant viewpoint and the predominant background represented in those discussions in order to get a rich discussion going. If it's just everybody coming to the discussion with the same background and same viewpoint, you'll get a very mooted and probably very inaccurate and one-sided discussion, which is not going to make for very good law and it won't make for very accurate law. Now, I can hopefully say more about that with some specific examples later on, but I don't want to go over my five-minute limitation.
Thank you, Judge. Sherilyn, how about if you go?
Well, let me start by reading two statements. I'm a Brooklynite, born and bred, a first-generation American on my father's side, barely second generation on my mother's. Second statement. I am who I am in the first place because of my parents. My father was brought to this country as an infant. He grew up in poverty. Although he graduated at the top of his high school class, he had no money for college. In the midst of the Depression, he found that teaching jobs for Italian Americans were not easy to come by and had to find other work. Those statements are, first, the statement of Justice Ruth Bader Ginsburg as she opened her confirmation hearings for a seat on the Supreme Court. And the second is the statement of now Justice Samuel Alito when he began his confirmation hearings to sit on the Supreme Court. And later, Judge Alito went so far as to, in recounting his experiences and his family background, say, when I get a case about discrimination, I have to think about people in my own family who suffered discrimination because of their ethnic background or because of religion or because of gender, and I do take that into account. The response to Judge Alito's statement was, thank you, by the senator who asked him the question that elicited it, and it was subject to no more controversial discussion thereafter. It's now become standard for nominees to the Supreme Court to talk about their background, to talk about usually their humble beginnings. I mean, I don't know that in my time of watching Supreme Court hearings that I've heard any nominee say, you know, I come from a privileged and wealthy background. We had a nanny until I was 12. I went to the finest, prep schools. No one says that. Everyone tries to give their humble and if they can, working class bona fides, to give a sense of context. Why do they do this? Why do they tell us that? I mean, they're a nominee to the Supreme Court of the United States. What's required is for them to have a certain skill and background and knowledge of the law. They don't even technically, I suppose, have to be a lawyer, although practically they do. Why do they tell us this? They tell us this to cue to us that they have something more to draw on than what they learned in law school, than what they've derived from law books, than what they've learned in the courtroom. They're cueing to us that there's something about them that is like something about us, and that when they decide cases, when they're in the conference, when they're taking on this incredibly important job, they bring to it experiences that mean that they can be proxies for us. They are in the conference room and we are in the conference room because they have come from the kinds of experiences that most of us, or at least many of us, have come from. And we all like that. It goes over very well at confirmation hearings. And yet when we push and we probe and we really get to the point of asking, how does that happen? How would Judge Alito take that into account, for example? We regularly retreat back to talking about judicial umpires calling balls and strikes. We don't want to confront the how. I was really struck by this in preparation for the Sotomayor hearings, which I also watched gavel to gavel. And I'm a, judicial selection geek, so, I love this stuff. And in preparation, I went back to read all my old hearings, which I really like. And so, I know, it's terrible. It's really very sad, but very exciting. And so I talked to my librarians, and they were pulling up all the old confirmation hearings, and I started to read some of them. And one of the ones that struck me most was the confirmation hearings of Justice Ginsburg. And I was particularly interested in her confirmation hearings because I knew that her background was a fairly liberal background by current standards, but that she had received overwhelming support. And I wondered kind of how did that go? What did that look like? And of course, she was also a woman. And what I was really struck by, particularly as the Sotomayor confirmation hearings unfolded, was the very rich and robust discussion of gender and gender discrimination in the law that marked the Ginsburg hearings. Not only in her discussions about her work as a women's rights lawyer at the ACLU and the clients that she represented in a variety of cases, but also her explanation to the Judiciary Committee of how gender bias worked and why many men, including male judges, didn't really get it in the time that she was first litigating her cases. And then there was also a very rich discussion about her own experiences with discrimination, not only with gender discrimination at law school and on the Harvard Law Review, when she couldn't invite her mother-in-law to the Harvard Law Review dinner because the dinner was only for those who were on the law review and men. So she could invite her father-in-law and her husband, but she couldn't invite her mother-in-law, who was her biggest champion in the family. But she also talked about her experience with discrimination against Jews and seeing signs when she and her family went on vacation that said, no Jews or dogs allowed. And there was a very moving conversation between her and Senator Arlen Specter, who is also Jewish, in which he acknowledged not seeing those signs, but also acknowledged having been exposed to anti-Semitism and discrimination against Jews. And so there was this very rich conversation about not only who she was, but about how who she was affected her experiences and her understanding of discrimination in the law. And I was struck by the fact that in the Sotomayor confirmation hearings, the confirmation hearings of the first Latina Supreme Court justice, there was never any conversation of any sustained or even brief nature about discrimination against her as a Latina. The idea that we have someone sitting before us who has the kind of background and experience that she has, and yet her own personal experience with discrimination never came up, was never probed. She never had an opportunity to explore that. She's also someone who was diagnosed with diabetes as a child. And I thought that we would hear some maybe interesting and important stories about the ways in which and the difficulty she must have had obtaining the kind of accommodation that she probably needed as an insulin-dependent diabetic as a young child in the days before the kinds of accommodations that we come to expect today were fully in place. There might have been a conversation about her parents receiving language assistance materials to vote in New York, her parents both Spanish speakers, and who, because of amendments to the Voting Rights Act, were entitled to language assistance materials in New York for voting. None of that came out. None of what I thought were the very rich aspects of that background came out. Why didn't it happen? It didn't happen because in the weeks before the confirmation hearings, a drumbeat had begun and has been alluded to earlier based on one statement from a variety of speeches that Judge Sotomayor gave. And there was a deliberate decision to isolate that one sentence from her speeches and to use it to put Judge Sotomayor on the defensive. In fact, to compel the first Latina Supreme Court nominee to spend most of her time at the confirmation hearing convincing the all-white, Southern-dominated Senate Judiciary Committee that she was not a racist. The question that was posed at the very outset was this an opportunity lost? Yes, I think it was an opportunity lost. I think we lost an opportunity to do, hopefully, what we'll spend some time doing today. Yes, I need a life, and maybe I'm a geek for reading all these old confirmation hearings. But I'll tell you, one of the most difficult and painful ones to read is the confirmation hearings for Judge and then Justice Thurgood Marshall to the Supreme Court. Remember that by the time he was being confirmed for the Supreme Court, this was his third set of confirmation hearings in, I think, a 6 or 7 year period. He had first been appointed to the Second Circuit Court of Appeals and then had confirmation hearings as Solicitor General and then to the United States Supreme Court. So it wasn't like the Senate Judiciary Committee didn't know who he was and hadn't had an opportunity to question him. And when I listened to some of the questions that were being asked of Judge Sotomayor, in which she was being asked to prove that she was not a racist, I remember that Senator James Eastland, the chair of the Senate Judiciary Committee in 1967 and a notorious segregationist, asked only one question of Thurgood Marshall at his Supreme Court confirmation hearings, and that was, are you prejudiced against whites in the South? That was a long time ago, and yet it seemed not so very long ago when I was watching the confirmation hearings. So there's a lot we could say about the Sotomayor hearings, but I really want to talk about what I think are the two reasons to vigorously promote judicial diversity, and I'll lay them out very briefly with the understanding that in our conversation we'll have an opportunity to explore them at greater length. One which I think many people understand, agree with, or are on board with, is the idea that judicial diversity promotes public confidence in the judiciary. That is, when we see a judiciary that is made up of a variety of experiences and a cross-section of the community, then the public has more confidence that the judiciary is not set apart, is in fact derived from the people, and understands our society and reflects and represents our society. And of course, this is no small matter as it relates to the judiciary. The judiciary requires public confidence in order to maintain its legitimacy. Judges have no armies. Some of them have very burly-looking bailiffs, but they have no armies to enforce their decisions. And they rely on the public, on the public's acquiescence, on the public's belief that our judicial system is legitimate and therefore we will follow their decisions. And so that's one reason why diversity is important. The more difficult question, and the one that I hope not only we today, but as we go forward we'll spend more time talking about, is the potential that judicial diversity has to make judicial decision-making better, richer, broader, deeper, as more perspectives and values that exist in the community, that as more backgrounds are included in that conference table that Judge McKee talked about. When Justice Marshall retired from the Supreme Court, the Stanford Law Review did a tribute volume to him, and several of his colleagues on the court talked about Justice Marshall's contribution to the court. And I wanted to just read two of the things very briefly that were said that I think reflect my point. Justice O'Connor said, Marshall, in the conference, where Marshall was famous for telling stories about the cases that he had been involved in, the clients he had represented, and his own experiences as a young civil rights lawyer, O'Connor said, Marshall imparted not only his legal acumen, but also his life experiences, constantly pushing and prodding us to respond not only to the persuasiveness of legal argument, but also to the power of moral truth. Justice White said something I thought was actually quite honest and compelling. He said that Justice Marshall would tell us things that we knew but would rather forget. And he told us much that we did not know due to the limitations of our own experience. When we talk about judicial diversity on the bench, I think it's so important for us to remember that we mean all kinds of diversity. We mean racial diversity, of course. We mean gender diversity. We mean background diversity, and I hope we'll have an opportunity to talk about that as well, the various professional backgrounds that should be represented on a court. But I do think that, as Judge McKee alluded to earlier when he suggested that people who say that there's no way that bias has influenced them, may be lying to themselves. That may be true. It may be also true that for many white judges, the transparency of whiteness in our society, the sense of whiteness as being the norm, of not being a race in fact at all, is what enables a white judge or justice to say, I never let anything racial influence me. The presumption is that if you did, that would make you racist. But the reality is, as the great judge Constance Baker Motley once said in a case in which she was asked to recuse herself in an employment discrimination case because she was a black woman who had been a civil rights lawyer and a lawyer for the Legal Defense Fund. And she refused to recuse herself from that case, saying, everyone has a sex, everyone has a race, and everyone has a professional background. Why would a white judge be in a better position to impartially decide an employment discrimination case when one of the parties is the white defendant than a black judge when one of the parties is a black plaintiff or a woman plaintiff? And so I think we have to begin to probe behind this issue of transparency and be more honest about the reality of our differing perspectives and backgrounds, and be unafraid to admit that in the small slice of cases that Judge McKee talked about, it matters. Thank you.
Thanks, Sharon. That was terrific. Sylvia, how about you?
I'm going to follow up and cover maybe a little bit of stuff that Sherilyn has already covered, but I'm going to take just a slightly different tack. And let me start with where she was talking about why a diverse judiciary. I think it's important to go over why we value that, because I feel that the Sotomayor hearings were really an attack on the idea of why we value a diverse judiciary. So let's take a step back. First of all, as Sherilyn pointed out, you want public confidence and legitimacy. One type of diversity that does that is just having the number of judges that look like you on the bench. And in terms of that area, in terms of how much progress we have made in America, we actually have done pretty well, thanks to the Clinton and Bush administrations. If you look at the number of African-American judges currently active on the court today, we have 90 federal judges that are African-American, representing about 11.2% of the total. And when you compare that to the actual representation in the U.S. population, that's 13.4%. That's pretty good in terms of representation. And that's the group that is most well represented in terms of the federal bench. When you go down to Latino judges, we have 51 federal judges. And of those, George W. Bush named 23, or almost half, of those currently serving on the federal bench today that are Latino judges were appointed by George W. Bush. And they represent 6.4% of the federal bench in terms of total population. Latinos are 15%, so that is still a little bit off. When you look at the Asian American population, you have 6 federal judges that are Asian American.
0.7% of the federal bench, 1.5% is representation in the U.S. population. But oddly enough, you have some regions, for example, the northern region of California, where there is a heavy Asian American population, and you still don't have a single Asian American judge. So there's still a lot of work to be done there. And for Native Americans, I was just talking to our friend Richard Guest. The numbers are 0, 0, 0, 0 across every president. So there is no federal judge that is Native American. And when you think about the fact that the norm now is that you must be a federal judge, usually to be named to the Supreme Court, it seems pretty remote that we'll have in our lifetimes a Native American judge named to the Supreme Court. But actually those statistics lead me to conclude that on the area of descriptive diversity, we've actually made a lot of progress. What other kinds of diversity, and where are we on those other kinds of diversity? Well, as Sherilyn pointed out, I think an important piece of why those of us that believe in judicial diversity is that we are convinced and committed to this idea that you come up with better decisions when you have a diverse judiciary. What's the evidence on that? Well, first of all, let's look at kind of the fact piece of it, right? Every decision has to be made with a set of facts. Yet we know in our society, and I think it's pretty much accepted these days, except for some Republicans on the Senate Judiciary, that people from different backgrounds will look at a set of facts in a very different kind of way. We have kind of the public lesson just recently of the Gates encounter over Mr. Gates' thought, viewed the facts in one kind of way, and the policeman viewed it in another set of way. Who is right? We don't know, but we know that their backgrounds and their racial backgrounds have a lot to do with how they view so differently those sets of facts. So the factual diversity is an important part of what goes on in the judicial process. This is kind of the Thurgood Marshall as a raconteur, him telling his colleagues, this is the way I see the fact. And it's this next piece of diversity, which I think is important, the piece where we go about problem solving. It's important to have diversity in a collegial setting where you have an exchange of ideas among equals, where you're doing it in a non-threatening, non-confrontational way, and where you have personal friendships established, as you might in a bench, in a circuit bench or in a Supreme Court bench, where you're really listening to that other perspective. It's not a stranger who's telling you about that other perspective, but it's someone whom you trust. And the psychological literature tells us that it's those kinds of settings when we are more likely to lessen our defenses about our racial or gender perspective, really listen and be perhaps converted to that other way of listening. And again, the data here in terms of the study show that it's in that collegial setting, when there are panels, where there are exchanges, when you see the presence of minority judges or gender a difference really making a difference in outcomes. When you have women sitting on the bench alone, their behavior in terms of outcomes is really not that different from a male judge. Or when you have a minority judge, for the most part, and there's going to be an exception that I'm going to talk about, their behavior is not that different from a majority counterpart. But the only studies that have shown a difference in gender, really making a difference in outcomes, are in these collegial panel-type settings. Now, this is my next point. Now, the political scientists have spent a lot of time looking at kind of outcomes. Does it really make a difference in terms of a civil rights case whether I draw a black judge or a white judge? And here is kind of a very brief summary of the results. President W. Bush's judges are among the most conservative on record, particularly in the area of civil liberties. When comparing George W. Bush's non-traditional judges, meaning his minority and women judges, to their white and male counterparts, their vote and behavior on civil liberties issues is just about identical. So it doesn't make a difference. In the case of President Clinton's judges, and again, remember, he accounts for a major portion of the other active federal judges. It's Clinton and Bush, W. Bush, that both had 8 years. So this is the mass of who's currently active right now. 2 recent studies conclude that trial and circuit judges are distinctly more conservative than judges appointed by Democrats Johnson and Carter. And the 3 studies conclude that Clinton's minorities and women judges are more conservative than their white male counterparts. There's another study by David Manning that shows that Latino judges were less likely to rule favorably on civil liberty cases than any other judges. In other words, if you run a Latino judge, according to these studies, you're probably going to get more negative outcomes on civil liberty cases than if you had drawn a white judge. So in terms of outcomes, the data show that it's very, very small, the difference between having a white judge or a minority judge when it comes to individual cases. Again, to repeat, the only place where we're seeing these differences are in panel data. And there's another place where it really makes a difference to draw a minority judge versus a white judge. And in this case, I want to be more specific, an African American judge versus a white judge. And these are in what are called racial harassment or racial environment harassment cases. These are the cases, Title VII cases, where you have an employer who creates a hostile racial environment. The supervisor, calls a woman consistently the black bitch. If you do, it's a very interesting exercise. Do a Lexis search and do black within 5 of bitch, and you will come up with all of these cases. And most of these cases come out against the plaintiff, against the woman who is being called black bitch on a consistent and regular basis. Why is it that that plaintiff is losing out? You would think that if you're getting called black bitch by your boss all the time, that you should be able to win that Title VII cases. It's because the standard is that it has to be prolonged and it has to be directed to that individual because of her race. And what you'll find in many of these cases is that the employer is just an asshole. Excuse my language. A generic.
This is an adult conference.
I mean, he will call somebody a fat slob, and he'll call the gay person, something else. So it becomes very difficult to say this is directed at that particular person. To take a step back, in these kinds of cases, it makes a significant difference to draw an African American judge. That judge is going to be 2.5 times more likely to perceive that that environment is in fact racially directed. If you get a Latino judge, he is probably going, or she is going to be less likely to see racial hostility. And white judges, as I said before, only see racial hostility in these kinds of environments 17% of the time. It is a tough case to win. So only in these situations do you really see a significant difference between individual black judges and individual white judges coming out with different determinations. And I would argue to you that that is because they see the facts differently. They have lived that experience, and they understand discrimination in a different kind of way than their other counterparts. And I'm going to add one more piece of what I'm going to call is important about diversity, and that is that judges have this function not only of coming out with the right decision, but also of explaining why they came up with that decision. Now, I don't know about you guys, but I have this experience, I have this memory in law school of reading these cases and thinking to myself, where did this person come from? What universe are they living in? This is not my life. Their facts and their explanation is totally crazy. It's this process of explaining why you're coming up with this decision, not sounding condescending, not sounding like you are talking as a white male judge, but talking as a judge that understands the realities of everybody, coming up with these rationales that I think is a very important part of the legitimacy function of the judiciary. And I think that a diverse bench, the process of writing an opinion where you have to all participate and say, hey, this is crazy, maybe you need to drop a footnote here, is one reason why we need to have a diverse judiciary. Now let me now switch to what happened at the hearings. As I mentioned before, I thought my view of the hearings is that it was an all-out attack by the white Republican male senators on the idea and importance of diversity on the bench. You have 17 questions on the Wise Latina comment, and they're all phrased around this idea of you must really be biased and you must be Judge Sotomayor. We don't think that you can judge neutrally. We don't think that you can judge in a way that is consistent with the American system and the rule of law because you have said that your wise Latina experiences is going to lead you to sometimes making better decisions than a white judge. And Lindsey Graham in the confirmations hearing said it flat out. It really bugs me that you said better. Maybe different is okay, but you said better, and that's what's really bugging me about this whole thing.
The hell out of me.
Yeah, he said that.
Since we're at the adult conference.
Yeah, and then you had Sotomayor, starting on day 1, trying to explain it. Life experiences are important to the process of judging. They help you understand and listen, but law always requires the result. That's a pretty good explanation of what she meant. She also said life experiences have to influence you. We're not robots. We're human beings. Of course, that's what I was talking about in terms of white experiences. She then says, becomes more apologetic. I don't believe any ethnic, gender, or race group has any advantage in sound judging. Then she called it a rhetorical flourish that fell flat. She appealed to the American people. Hopefully the American people can understand the context in which I was talking about and understand my intent, my good intent in talking about. And on the final day, the final session with Lindsey Graham, she finally said, I regret that I have offended some people with my comment. And that was, I don't know if that was a retreat, but it was. She was beaten up so harshly on this Wise Latina comment that you felt that there was no room to really acknowledge what we kind of all know at this point in our development, or should know in our development, that we do see life differently, that our experiences do shape differently what we're doing. And there's plenty of psychological data, there's plenty of experiments, there's plenty of good books out there that show this over and over again. And yet she had to retreat on this idea that, yes, she views life differently, and she thinks that experience will make her a better judge. And I guess I would argue that she didn't have to retreat from any part of her comment. She says, it's going to make me a better judge. In the context of being the only Latina in a conference room full of judges that have never had that Latina experience, it may well be that her ability to bring in a life experience, what it's like to be a Puerto Rican, what's it like to live life in a border on particular issues, will make that decision at the end a better decision. In other words, going back to my original comment, that it's the give and take that I think produces a better decision at the end. And it would be true that if she's the one imparting some knowledge to the group that's all white, that has never had that kind of knowledge, or to the group that has always been English speakers, has never had the experience of struggling with language, or to the group that is not diabetic, what's it like to take a diabetic shot, that her experiences as this wise Latina woman will make that decision better overall. We didn't have that conversation because she basically had to do so much defensive maneuvering with the attack on her of being not impartial, not being neutral, and not being prejudiced. In fact, at one point, Justice Kyle said to her, you know what? She wouldn't. It was Justice Cornyn. I don't want to libel anybody. It was Justice Cornyn who said she will get on the bench and advance the causes of ethnic groups. All right, so it's a kind of frontal identity politics kind of attack on her. All right. I think, what did we lose, in this kind of discussion? I think we lost not only this idea that we perceive the world differently, we also didn't talk about, as Judge McKee said, this idea that the law is quite flexible. This 5% of this decision, Durbin at one point says, does anyone believe that there is only one objective answer to every issue that comes with it, from the Supreme Court? But yet that's what was imparted overall in the hearings. Did we talk about the importance of having a voice of color on the bench, on the federal bench? And did we talk about the fact that having a voice of color is not antithetical to the American system, as Jeff Sessions said over and over again? Did we talk about this temperament issue? Why is it that when women judges are questioning vigorously an attorney, she is a bully, which Lindsey Graham repeated in the hearings, versus just being a tough questioner? Did we have any discussion of why it is that most women, and I think here we have some data on that are sitting on the bench, get questioned about your judicial temperament more vigorously than male judges? And did we talk about this kind of what I call unstinting colorblindness? In fact, I think these hearings kind of reinforce the unstinting colorblindness, this idea, as Sherilyn mentioned, that any time that you deviate from the white norm or the male norm, you are challenging neutrality. That to be neutral, you must be white and male. Why can't you just have some other perspectives come in and not be those perspectives coming in that makes us a more kind of fair and balanced society and a judiciary? And finally, and I guess my own personal regret on these hearings is that this moment of taking pride in having the first Latina justices made to the Supreme Court was totally quashed. It was like having cold water or cold Gatorade put on you before you got to be the victor. You got the cold bath before you got to celebrate. Wow, we got the first Latina justice. The Democrats' speech was, this is the best justice, right? Just like Justice Thomas was the best justice available, according to George W. Bush. And there was never kind of a push or pull out there made to kind of articulate why it is so important to get that first Latina justice or Latino justice to the Supreme Court. You even saw it in the way that the Democrats handled the introduction of Sotomayor to the judiciary. Who introduced her? The Senator Schumer, the two white senators from New York, and you didn't have a Latino senator. You didn't have a Puerto Rican congressman or congresswoman come to the judiciary and say, it's with pride that I come to introduce to you the first Latino justice. And the Latino people take great pride in this. We have a great feeling of belonging, of finally having arrived. It's important for the Democratic Party to reach out to Latino voters and to tell them that we understand their situation and that we want to put a justice on the Supreme Court that will champion the rights of your group, of your ethnic minority, the way that a Latino justice can understand what your rights and your civil rights struggle is all about. That moment of saying to the American people that one of the most important civil rights struggles that we have ongoing right now is a struggle over language rights, it's a struggle over immigrant status, it's the struggle over having an educational system that has access to everybody, did not get stated in this confirmation hearing. And why? Because we cling to this myth of colorblindness, because we cling to this idea that we really are all the same, and we lose a great deal from that. And I would venture to you that the Democratic Party lost a great deal in shying away from that pronouncement.
Thanks, Sylvia. Chara Torres-Spellacy is from the Brennan Center and has done some work on judicial diversity in the states, and she's going to talk a little bit about that.
Thank you, David. Good afternoon. My name is Chara Torres-Spellacy, and for today's presentation, I'm going to focus on gender. The nomination of Sonia Sotomayor to the Supreme Court has provided the opportunity to consider the pipeline of where Supreme Court justices come from. Recently, they come from state Supreme Courts, like Justice Souter, and from federal courts of appeal, like Alito and Roberts. And yet these feeder courts themselves are not very diverse. In the Eighth Circuit, for example, there's only one female judge. And in fact, Judge Murphy has been the only woman to serve on the Eighth Circuit in its entire history. The 10th and 11th circuits are doing slightly better with 2 active female judges apiece. Meanwhile, in the states, 24 state Supreme Courts are all white and 2 are all male. At the Brennan Center, we tried to get down to brass tacks in our study, so we interviewed members serving on judicial nominating commissions to see how diversity comes into play during the nominating process. Looking at our 10-state sample, we found that in most states, racial and gender diversity on the bench lags behind the diversity of the state's general population, their bar memberships, and law student populations over the past 20 years. So how bad are the numbers? The national data reflect a severe disparity. White males are overrepresented by a margin of nearly 2-to-1 at the state appellate level compared to their share of the general population. And almost every other demographic group is underrepresented. There are still fewer female judges than male, despite the surge of female attorneys into the profession. And this pattern is prevalent in the highest courts. In 2008, according to AJS, 14 state Supreme Courts have just 1 female member, and 2 state Supreme Courts have 0 female members. That's Idaho and Indiana, if you're curious. And these facts are jarring, given that, according to the Bureau of Labor Statistics, there are about 325,000 female attorneys working in the United States today. And I look at this as a human resources and talent pool issue. And I come to this from my background of being at Harvard and Columbia, where there were hundreds and hundreds and hundreds of incredibly gifted, or what we call in Cambridge, wicked smart, women and minorities. And they are now funneling their way through the legal profession. And it's my hope that at least some of them will end up on the bench. Because as a nation, we need that type of talent in the government, especially in the third branch. So what was holding up efforts to diversify the bench? There were many things ranging from judicial salaries to retention elections. But what I'd like to focus on today is the problem of implicit bias. New research from the field of cognitive science on implicit bias may explain in part why racial and gender disparities on the bench persist, even when nominating commissions believe that they are open to all applicants. Cognitive researchers have observed that humans stereotype others unconsciously, even when they profess tolerance consciously. These biases typically work against disfavored groups, such as racial minorities and women. And we pick up these biases early in childhood, and they are never fully dislodged. Yet, as Justice Brennan wrote in Price Waterhouse, unwitting or ingrained bias is no less injurious or worthy of eradication than blatant or calculated discrimination. And I have 2 examples of how implicit bias can work. One is from the unlikely world of orchestras. Researchers have found that when female and male virtuosos are auditioning for first violin, the man often gets the job. But if the musicians audition behind a curtain so that the gender of the applicant is unknown, more women get the job. In other words, the image of a first violinist being male is sort of so overwhelming that it trumps the actual notes that are being played. And this strongly suggests that female violinists are disadvantaged simply by being women, even if they can play the violin better than their male competitors. And when I say that children pick up biases early, I really mean in the first years of life. So the second example I have is from my own childhood. When I was in first grade, my very clever first grade teacher showed the class a picture of the Warren Supreme Court. and she asked us to describe the people in the picture. At 6 years old, none of us noticed that they were all white men, until we could compare it to another picture of the court from 1981, which contained Justice Sandra Day O'Connor and Justice Thurgood Marshall. Then we had our eureka moment, that it wasn't inevitable that judges were white men. So back to the Brennan Center study. One of the challenges in increasing diversity on the bench is prospective applicants' pessimism. In our study, we found a Utah commissioner who believes that a sizable number of women and minorities view their diversity as a liability when precisely the opposite is true. A commissioner from New Mexico shared this concern and said the biggest obstacle in diversifying the bench is potential candidates who assume they are not judicial material, and that on top of that, New Mexico's commissioners also make the mistake of assuming that certain individuals are not judicial material because they have stereotypes or biases about what judicial candidates should look or act like. As an example, she worries about younger female Native American candidates. As she said, clearly, that candidate is not going to look and seem like other judges, but her resume may show that she has all of the qualities necessary. And here we have evidence of how implicit bias works in the real world. On the one hand, disadvantaged groups may underestimate their own chances to become a judge. Meanwhile, commissioners may exacerbate the problem by sharing or reinforcing these low expectations. So a key factor in solving this problem is getting the word out that the door is really open, which means recruitment, recruitment, recruitment. But at the same time, diverse candidates also have to walk through that open door. As former New York Chief Judge Judith Kaye once said about her own appointment to the bench, which itself started with her applying, a miracle can happen to you only if you have ambition. It's very, very good to dream large. What's more, for a miracle to strike you, you have to put yourself in the right place. And with that thought, I'll yield the floor.
Well, thank you, Tara. I'd like to ask, since this is partly for my own benefit, I need to write about later this week about Justice Sotomayor and what she's going to bring to the Supreme Court. So I was interested if the panelists can say, we've sort of agreed that diversity is a good thing. It brings a richness of experience to the court. Tell me how you think the Supreme Court will be different, or Justice Sotomayor will have an effect on the Supreme Court. That's, there's one conventional view is she's the replacement for David Souter. David Souter's a sort of moderate liberal. She'll sort of plug into that slot and nothing will change. I'm interested in your view about how cases, decisions, how she might influence the court that in some way grows out of the fact that she's something different. She's something new. She has a different background than other justices.
Some of it's going to depend on how far she wants to go in that direction, how comfortable she feels. And that just might take some time and some growth. Because what Sylvia said about the trust that grows out of the conference is very important. There are a couple of examples. I can give you one. He's no longer on our court, and when I say that, it's not Sam Alito, but a very, very conservative member of our court. We had an immigration case, and this is not something even that requires diversity. I think it just requires having your antenna up to other people who are very ethnocentric. And you see this an awful lot in immigration cases where we are supposed to defer to the superior expertise of immigration judges. And what at least I found, and I think a lot of my colleagues would agree with, is that there are a number of immigration judges who are particularly culturally ethnocentric and unsensitive. This was a case where a person, I'm not sure what country he was from, I think he was Sierra Leone, saying that if he went back he would be persecuted because of his vicarious political belief associated with him because his father had been the lead of an opposition candidate who had tried to oppose the current leader of Sierra Leone, that he, the asylum applicant, had been beaten up by some forces of the current regime before he came. He was concerned that if he went back, he was going to be targeted, beaten up, and persecuted, thrown in jail, and some really bad things going to happen to him. The immigration judge didn't believe him because the asylum applicant did not have any corroboration for his testimony. And we have cases in our circuit, I guess most circuits do, where we said the applicant's testimony in and of itself can be sufficient to sustain the applicant's burden of proof. But there are also cases that say that it's not improper for the asylum officer, the asylum judge, to deny asylum if the testimony of the applicant is uncorroborated. This was a situation where the immigration judge said, the testimony is uncorroborated, I don't believe him, and therefore he goes back, he doesn't get asylum. My colleague wrote the opinion, it was a non-presidential opinion, affirming that, and he said that there was no corroborating evidence. And he wrote this opinion, and according to the asylum applicant, he was confronted by a mob which was stirred up in his village by some local ambassadors from the regime that his father had worked to oppose, been beaten up, gone to the hospital, hospitalized for 2 days, and then returned home. On his way home, he escaped his village. So I said to my colleague, well, what corroboration would you expect him to have? And my friend said, well, he said he was beaten up by a mob. There were a lot of people around who saw that. There's no witness statements from anyone corroborating the fact he was beaten up. And I said, even in this country, you cannot go on the street and try to find anybody who's going to come forward to corroborate you in a situation because you don't want to get involved. If this guy is telling the truth, anybody who stepped forward would put themselves in danger and endanger the lives of their family. I said, well, okay, that's true. Then he said, well, what about the medical records? And I said, have you ever seen, my friend said he was in the hospital for 2 days and there are no medical records. He said 2 things. First of all, have you ever tried to get your medical records from a United States hospital? Beyond that, and I recounted to him a hospital that I saw going from Accra to Kumasi in Ghana. It was this mud hut, literally a mud hut, with a tin roof on it. The only way we knew it was a hospital was because outside somebody had written, I guess to emulate the Red Cross, HASPLE, meaning hospital, and was kind of a Red Cross painted on. That was the hospital. And I said, have you seen rural hospitals in third world countries in Western Africa? He said, well, I guess you've got a point there. And I said, if there's something out there other than corroboration that tends you to believe that this guy didn't make out his claim, okay, but you can't say it's because he didn't have witness statements, which you can't fairly expect him to get, or medical records, which would be impossible to acquire. And if our standard is going to be requiring medical records from people in rural areas where they don't have access to medical treatment, we might as well just hang out a sign outside that says all asylum applicants need not do anything but get in line and to go back home where they're going to be persecuted. He thought about it, and he actually called me and then came back to my chambers, and he said, Ted, I think you're right. There's not enough there to support the adverse credibility ruling, and I'm going to vote for credibility for asylum, and the person got asylum. And there's one other case like that where the same person, we exchanged some memos, and he agreed that I was right. There was one case where I agreed that he was right, and I changed my mind. And now we have I don't see him very often, but we have a very long, I think, an enduring friendship of mutual respect. We listen to one another. And that doesn't happen in the average situation. And again, that wasn't necessarily because I was black or because I traveled in West Africa. It happened because I try not to look at things that happen through the eyes of a industrialized society, and I understand that people who come before us from different cultures come from very different sets of circumstances. One other example like this, in an en banc opinion, and this was published, the name of the case was, we pronounced it Dia. It's spelled D-I-A, where the immigration judge had denied the alien's petition for asylum because he said he got to the border, was smuggled out of his village by an asylum officer whom he gave $25 to, by a local police officer. He gave $25 to get him through the countryside and get him across the border. Well, the immigration judge did not believe his testimony because he couldn't believe that any police officer would be willing to risk his career and risk arrest for $25. Well, even in the United States, that's not true. But in the country he was talking about, $25 happened to be 45% of the annual per capita income, which is a big chunk of change. And when that was factored in, and that was not a unanimous opinion, but when that came out in the course of the dialogue, it became obvious that there is absolutely no basis whatsoever to disbelieve what the alien was saying. And again, it's based upon looking at something not through the majority mindset, not through a lens of ethnocentrism, but being attuned to the fact that the reality that we see is not everybody's reality, and we can't judge other people or the reality by our own reality. That wouldn't have required diversity. That would have required just, I think, some common sense on the part of some of my colleagues that they sometimes don't always manifest to the extent that I would like to see. I'm trying to say that in the cleanest way possible, manifested. But I think it comes in the answer to your question because it's a way that diversity can and will manifest itself. And that's hopefully Justice Sotomayor, I think her background is such that she is able to bring to bear in the course of the dialogue. And that really is where the exchange happens. It's after the oral argument, when the doors are closed, we're in there with other law clerks, it's just us and our colleagues, and there's an exchange of ideas that takes place and maybe some follow-up memos after that, where if your colleagues are willing to listen to you and if you're willing to listen to your colleagues, there really can be a dynamic exchange of ideas, not as often perhaps as I would like, but it does happen. I mean, the trick is knowing how often to push, how far to push, because to the extent you push on every single case, you lose some of your credibility. So it's the old thing of knowing which battles you can compromise on, which battles you have to compromise on, and which battles you can't compromise on. After a while, you develop what I call a gag rule, that if it doesn't make you gag, you go along with it. And I think that's the kind of dialogue that she may well be able to foster on this report.
I wanted to weigh in on this because I think the presumption has been erroneously that when we talk about making decisions better and when we talk about how diversity can affect judicial decision making, that we're always talking about changing the outcome of the case. And I want to say at the outset, at least for me, I can't speak for the other panelists, that is only one means of determining whether or not or how diversity affects judicial decision making. But if we go back to the earlier comments that we made about public confidence and legitimacy, all that we can hope for is that a judicial decision has been tested by a variety of perspectives, viewpoints, areas of expertise, and critical thinking. And so part of what diversity is bringing to the table is including voices in the process. It may be that at the end of the day, the panel all reaches the same decision or the Supreme Court all reaches the same decision. What gives us confidence as the public, or what should give us confidence, is the knowledge that some aspect of understanding was not excluded from that decision-making process by virtue of the fact that it wasn't in the room. And so part of what we're talking about is not just outcomes, but part of what we're talking about is process. So when we say, or even when Judge Sotomayor talked about, better decision-making is decision-making that is as sound as it can be because it's been as informed as possible by the variety of perspectives that exist within our legal community. Now, going to Judge Sotomayor, for example, one of the things that I think has not gotten enough attention is the fact that she was a trial judge, which I actually think is critically important. I'm a big stickler, as those of you who are in the audience who are lawyers are, practicing lawyers are, for the record, because you know how hard it is to create the record that you want to create. I always tell my students that until you take your own case on appeal, you don't know how bad a lawyer you are. When you get your case on appeal and you look at the record that you amassed and you realize what you didn't get into the record and how what you did get into the record doesn't look exactly like how you thought it was going to look, and you realize that this is what the appellate judge is going to read and that's it, you realize what a job you did at the trial level. Judge Sotomayor being a trial judge means, and there were many people who said this about her in interviews after she was first nominated, she knows how to read a record and she thinks it's important. And I have to tell you, I have listened to some Supreme Court oral arguments, including the oral argument in the voting rights case, and I saw a very loose, what I would describe as loose attention to the record. I saw a lot of kind of ad hoc adding in and shading of the facts, not adhering to the factual record that had been developed below and that really should have cabined the case. So I think her experience as a trial judge is critically important, and to the extent that she brings that discipline of understanding what happens at trial, understanding how the record gets shaped by lawyers, understanding the influence that judges have at trial in admitting or excluding evidence, that I think that's actually really important to have in the appellate panel. So I think that's great that she's going to have that to bring to bear. And last thing I would say is just that it was the Supreme Court that, in a set of cases talking about the importance of ensuring for the litigants' due process rights, that neither women nor African Americans are excluded from jury decision making, said that excluding any one group from the jury impoverishes the decision making of the jury by excluding a variety of perspectives and human experiences which are perhaps unknowable and unquantifiable. And I would answer the same for our other legal decision makers, for judges. To the extent that, we want to take out a chart and say she's going to bring this to the table, she's always going to be able to say this, she's always going to be able to say that, we can't know. But we do know that we create the potential for more enriched judicial decision making by ensuring that we have a set of judges who, in that conference, in that give and take, come to this from a variety of different perspectives. And it's one of the reasons, incidentally, and maybe we'll get to this later, why I think the issue of professional background diversity is one that also has to be addressed on the Supreme Court. And it's not perhaps a coincidence that it actually cross-cuts with gender and racial diversity, because the more we begin to look outside of U.S. attorneys and sitting courts of appeals judges, we actually find that we have a greater pool of women and minorities to choose from if we're thinking about those who would be on the Supreme Court as well.
I agree very much with that. Let me just quickly say, I think that the background of the diversity of different areas of practice is very, very important. The fact of being a trial judge is crucial. But also I want to emphasize that it's important that you don't leave here thinking that the minority judge, no matter whether that's racial or gender-based, is going to, by his or her ability to identify more with the plaintiff in a Title VII case, favor or make it easier for the plaintiff to win. There are lots of Title VII cases that I've looked at where I've said, why in the hell didn't they fire this clown 6 months ago? And lots of times the answer probably was they're afraid of a Title VII lawsuit. But it doesn't always mean, and I don't want to convey the image, that we are necessarily more deferential to or more sensitive to the interest in the case that reflects our background. I think it gives us a better and a more accurate picture of the dynamics of the case that may or may not inure to the benefit of the person in the case who's consistent with our background. As I said, there are lots of times when I've looked at a Title VII case with a black plaintiff, and I wanted to say to the employer, why did you tolerate this fool this long? And it was because I just wasn't, there's an old term which some of you may or may not know called wolf tickets. I wasn't buying some of the wolf tickets that this guy had been putting out over the years, and the employer had been buying them. And so it doesn't always mean that the plaintiff is going to have an easier time in, say, a Title VII case just because they've got a person on the panel that is of the same background as the plaintiff.
David, I have a list here of first or seconds of Sotomayor, so I'm going to read this out. Apart from being the first Latina, she's going to be the first native Spanish speaker, as I mentioned. And I think that's going to have an influence on language rights cases. There's a lot of stuff in No Child Left Behind about access to language rights, statutory provisions that are not being enforced. Flores' case this last term was a pushback on remedies of a really active federal district court taking on the Supreme Court saying you are doing too much in the remedy area. I think that her native Spanish-speaking background is really going to impart and get into some of those decisions. I would add here, accent discrimination is an under-litigated civil rights issue, and she would be someone who many of her relatives would have that kind of experience, and we may see accent discrimination come up more to the forefront. She's the first colonial subject to come to the Supreme Court. Puerto Rico is a colony. Her parents came to the United States really out of the situation of Puerto Rico being a colony, undereducated, underemployed. The only place you can go to have a decent living is to basically leave the island and leave the colony. We have legal constitutional issues that are confronting our colonies. We just don't have one colony. We have several colonies. United States citizens don't vote in United States election. United States citizens that are called statutory United States citizens, which means that you can have your U.S. citizenship taken away by an act of Congress. If those issues come to the Supreme Court, perhaps Sotomayor is going to take an interest in them. She is the second woman on the Supreme Court. She's the first divorcee, first childless woman on the Supreme Court. I don't really know how that's going to cut, but it is a different type of female experience than the more traditional marriage, traditional family that Justice O'Connor and Justice Ginsburg brought to the Supreme Court. She's her unique background as what I would call a member of the poverty urban underclass who made it well. Most people that grow up in a Bronx project that are surrounded by drug pushers, as she said that she was, don't make it. I mean, the vast majority succumb to the structural underclass and aren't able to bootstrap their way up. So she may pay more attention to the structural issues of class, poverty, and race that underlie many of the civil rights and general issues that we have that come before the Supreme Court. She's the first justice that describes her ethnicity in a way that I would call kind of salsa ethnicity. Let me read this way that she describes what it means to her to be Puerto Rican. This is, again, a law review article that didn't get much play in the confirmation hearings, but I find very interesting. About her Latina identity, Sotomayor believes that I became a Latina by the way I love and the way I live my life. My family showed me by their example how wonderful and vibrant life is and how wonderful and magic it is to have a Latina soul. I would have loved to have questioned her about that Latina soul and what does that mean. And did you experience discrimination? When you experience discrimination, how does that underlay this idea of saying that you're Latina because you love and you live your life? What do you mean by that? What's your racial identity? So her fix on racial identity seems to be pretty unique. And it will be interesting to see how that plays out in some of these cases. As I mentioned, she's the first diabetic. She has lived with a disability. She may have a special sensitivity to access to health care, and maybe in some of the immigration cases that we're seeing where immigrants in detention don't have access to health care, she may be a particularly strong voice. We have a lot of Catholics on the bench, but we don't have what I would call a Latina Catholic. My view is that there are different kinds of cultural Catholicism, and the Latino take on Catholicism tends to be a little bit more informal, I would say, than other type of Catholicism. I don't know how this would play out, but I think that might be interesting in terms of some conversations. Let's see, what else do I have here? I think that's my list of, and another thing that's very important. She's the second affirmative action baby to make it to the Supreme Court. The first affirmative action baby, I think, is Justice Clarence Thomas, although he has never admitted or confessed that he is an affirmative action baby. Sotomayor has actually said, yes, affirmative action helped me get into Princeton. But let's remember that, she graduated summa cum laude, and then also, because of her credentials, got into Yale Law School, and there she was a member of the Yale Law School. I think that having a minority on the bench who is willing to say, I'm an affirmative action baby, I think affirmative action helped give me the opportunity, but I also think that merit helped me succeed, may change the conversation around affirmative action, particularly to counterbalance what I view as Justice Thomas' more negative view of affirmative action. He tends to view it as kind of a mark of dishonor or a kind of a negative that he went to Yale, and many of his colleagues viewed him as an affirmative action admin. He tends to view the negative of it more heavily than the positive of affirmative action. So perhaps we'll see a more constructive conversation around affirmative action.
Can I just correct that Justice Ginsburg has always been very open
Okay.
about the fact that she says affirmative action helped her get her teaching job at Columbia, that everybody was looking to hire a woman, and that's how she got the teaching job. She's always been very open about that and talked about it at her confirmation hearing. So, the question is, when do we really hear that? When do we hear the words affirmative action? And I think when we're talking about racial affirmative action, there's a different response to it. But I do think that Sylvia's quite right that it will be interesting to have the contrast. If you read a lot of the opinions of Justice Thomas in affirmative action cases, he usually writes a concurrence or, well, I guess it would be a concurrence because usually he's in the majority recently in these cases. He writes his own opinion, and it's because he has very strong views about affirmative action. And if you've read his memoir, you know that he does have these very negative views and that he does see it as a stain. And I think that Sylvia is quite right, that having a justice on the court who can articulate the benefits of affirmative action and the role of that affirmative action played in her life in a way that is positive, I think is going to be very important to have in that conference room.
I'll just add in one short thing. I mean, the short answer is we don't know. We don't know what Sotomayor will do once she's unshackled and she has life tenure. But one thing I sort of hope for is, for instance, she was on the New York City Campaign Finance Board. So the campaign finance lawyer in me hopes that she brings some passion to that issue to the bench, which so far seems to be going entirely the other direction. So we don't know, but she has so many different aspects of her experience that she can bring to the bench that you hope that what she will bring is a check on the danger of groupthink.
I was amused yesterday that in opposing her, John McCain said, unlike me, she doesn't believe in judicial restraint. And I thought, she's going to get on the court in September. The first case up is going to be the constitutionality of the McCain-Feingold Act. She's going to vote to uphold it. The two that McCain likes very much, John Roberts and Sam Alito, will be the ones to vote to strike it down. We're running out of time, but I think we have some time for a few questions. And they've asked me to, whoever wants to stand up, is we need to bring a microphone over. How about right on the aisle here first?
Great, thank you.
Yeah.
Since LGBT issues cross all races, ethnicities, and genders, does the panel have any views with regard to diversity on the bench, inclusive of those of varying sexual orientations and gender identities?
Well, this is the first time I think I can recall, thanks for the question, that there was actually conversation about openly gay candidates on the short list for the Supreme Court. There was discussion about Pam Karlan and others. And it seemed to me that was kind of an interesting moment, a final moment in which that was kind of discussed openly as well. And so in terms of where we are with this on the Supreme Court, it's actually going to be, I think, quite interesting. I think the idea even of just, as Sylvia said, Judge Sotomayor being a divorcee and not having children, having an alternative idea about family. I mean, if you saw the family that was behind her, it was a lot of family, but it wasn't like her children and her mother-in-law and her father-in-law. Having a sense of that is going to be important to have in the conference room. And I think that having in this cycle, having had the conversation in a very open way about who's on the short list and having included in that conversation people from the LGBT community, that genie's out of the bottle. And I think going forward that that's going to continue to be a conversation until it happens, and ultimately at some point it will happen.
Anyone else? Another question over here, I believe.
Thank you. I'm Victor Stone. And Professor Eiffel's analogy to the selection of jurors and who can be excluded or not excluded makes me want to ask the panel how that relates to what they've been commenting on, because anytime I've had to select jurors, for example, in a stolen car case, if the judge will ask the panel, have any of them been victims of a stolen car incident? And if they say yes, the judge will excuse them, strike them on his own. Same thing if it's a drug case and he hears that they've been convicted of a drug crime. And yet all the same things that I've just heard Judge Lazos talk about Justice Mayor bringing to the conference are the very things that I've had trial judges say to me, no, you may not have those jurors bring those to the jury room because they're outside the narrow record, as Judge Eiffel pointed out, and the judge will say, that's for the advocates to make a record and argue. It's not for the jurors to hypothesize about. And yet, that's where I hear, at least it sounds to me, I'm sort of puzzled because that's where I hear these comments going. And so it leaves me a little, at least surprised about whether we're moving, the English system, as I'm sure you know, jurors were chosen from among people who knew you historically, not from people who did not know you, because they felt that people who knew you could judge whether you were going to tell the truth and whether your testimony was worth being credited. And we have a different system, which is if the jurors know you, they're struck. And if the judge knows you personally, the judge will often recuse themselves from your case. And yet, this sounds like we want to impute a little more. So maybe you can tell us where you think this is going.
I'm really glad you asked that question because, I got involved in looking at this whole question of judicial diversity because I began litigating a set of cases when I was a lawyer for the NAACP Legal Defense Fund in the late 1980s, trying to change the way judges were elected in various counties in the South. And the effort was to try and provide an electoral system that would give an opportunity for minorities, African Americans and Latinos, to be able to elect candidates to the bench in these various counties. And we were unsuccessful in those cases. We were successful in the ultimate Supreme Court case, which is that judicial elections are covered by the Voting Rights Act. But we were ultimately unsuccessful in winning those cases, particularly the one in Harris County, Texas, which I was litigating, which is the county that Houston is in, because the judges of the Fifth Circuit Court of Appeals said something like what you're saying. They essentially said that, if we change the judicial system, or the election system, to enable minority groups to be able to elect candidates of their choice to the bench, that is, to be able to elect African American and Latino judges to the bench, then those judges will feel beholden to that community, and it will undermine impartiality. And that set of decisions is what started me on what has now been an almost 20-year effort to write about and think about what do we mean by judicial impartiality. Because I actually was quite disturbed by the Fifth Circuit's conception. In other words, if I had to flip the Fifth Circuit's argument on its head, it would mean that what they were saying was that the current all-white judiciary, which was elected by the white voters of Harris County, was beholden only to those white voters, and that was okay. But if we changed the system to enable some of those judges to be elected by black voters, we would introduce bias into the system. And I say again that because I'm returning to my earlier point about the transparency of whiteness. When we talk about what happens in that conference room, we're talking about a variety of perspectives. White judges have racial perspectives too. They have racial experiences too. They may not have experiences being victims of discrimination, but they have their own stories that come from their own childhoods and the towns that they were in and the families that they grew up in and the jobs that they were in. And so they also have something to bring to the table. And one of the things I think is very corrosive about our conversation about diversity is that when we talk about diversity, people tend to think we're only talking about black people and Latino people and Asian people and Native American people. We focus on that because we're talking about including them into an area of the profession that has traditionally been exclusively white and male-dominated. But that's not to suggest that white judges and male judges don't have their own experiences that are part of the conference and that are legitimately part of the conference. As I often say, I'm not interested in having 9 African-American civil rights lawyer Supreme Court justices. I don't think that's the best way to get justice and good judicial decision-making in this country. What I'm saying is that what you want is to have a variety of perspectives around the table, not because the African-American justice is saying, I know what that's like, right? But because the African-American justice, as Thurgood Marshall did, is saying, you may not realize this from your experience, but when we read the record and we see that this was the colloquy that happened, here's the context for how that can happen. And if we didn't want that, if we didn't want judges to have experiences that they bring into the courtroom, which, by the way, aren't just racial experiences, they can be professional experiences. I've talked about, having been a trial judge and saying, like, this is what happens. This is why a trial judge might have excluded that testimony. That all of that is what helps a judge bring something extra to the table besides the judge's, I've practiced this many years, I'm admitted to practice, I have a clean record in terms of ethics. Otherwise, we could just simply put names in a hat, shake it up, and we'd pick out our judges. We'd say, listen, we've got the names of all of the lawyers who meet the minimum qualifications. Just put your hand in here and pick them out. No, we want something else. We want some tax lawyers and some corporate lawyers and some civil rights lawyers and some prosecutors and hopefully at some point some criminal defense attorneys on the Supreme Court. Why do we want all those things? Not because we expect the prosecutor for every criminal case that comes on the Supreme Court to side with the prosecution or to side with the state, but because we want that experience within the conference. And so that's one of the reasons why I suggest one of the things that's been excluded is criminal defense experience. We don't have that around the table. And so the same is true of race. It's not that we want any one race to dominate or that we expect any judge who, by the way, takes an oath of office and is a legal professional to simply say, I see the black person, I'm on their side. But what we want is for the variety of experiences to be represented and to, in that professional and collegial interplay, to connect with one another, to hear one another, to check one another, to ask the right questions, and then ultimately to reach an outcome, which may be, by the way, an outcome I don't like. But I feel confident knowing that in the room there was enough information for the court to make the best, most informed decision.
And I would be surprised by judges who did that. I was on the trial bench for 10 years, and 3 of those were homicide trials, only homicides. And I was amazed when you said that. When there's kind of a presumption that pops up that that's a juror who can't be fair. But it seems to me you've got to get into a dialogue and a colloquy with that juror and try to find out whether or not that's somebody who can set their own personal experiences aside, decide the case based only upon the facts in that case and the law as you explain it. And that could be somebody, I think you're absolutely right, who could be a very, very good juror if you as the judge become convinced that they're going to decide this case not based upon their own experience, but that experience may well inform the way they receive the testimony. I don't see anything wrong with that. I think that's what we're saying. But yeah, I was surprised to hear that. I would think that a judge would want to have a dialogue with that veneer person and try to find out, is this somebody that I should put in that box or not?
I think we have time for one more.
Thank you very much. It's really, really interesting discussion, and I think it should be carried on, actually, beyond here, even after the confirmation. I think it's a really worthwhile discussion to keep having. My question is, do you believe that the race narrative in the country is more pronounced and has more significance than the religious narrative? Because some of the discrimination ethnically, historically, has been against Catholics. Now we have 6 Catholics, or we will have 6 Catholics on the Supreme Court, right? We'll have, well, you know them all, right? You're all invited to the Red Mass, okay? So my question really is, and I wouldn't be so tough on her because we had to get her confirmed. I mean, the game was really to get her confirmed, and so you sort of had to play this goofy game and not really answer completely, wholly, truthfully on issues of like abortion and things like. So I mean, my question really is, it's sort of twofold. One, do you think that she did say enough and handle those delicate abortion type questions as well as you wanted to hear? And secondly, do you think that the ethnic, sort of the anti-Catholic bias in the Irish community, I mean, there were Nina signs, no Irish need apply signs in my dad's generation. There were, Dago jokes when I was little in Philadelphia, right? I mean, there's historically anti-Catholic bias in this country. So do you think that should do you think basically that the religious narrative is subordinate to the race narrative, and how did she handle the abortion question in your view?
I think she handled the abortion question the only way she could, and that's to not handle it at all. And I think a lot of that is very defensible. I mean, you can't touch that. You absolutely can't touch that. Even if you go too far explaining why you can't touch it, you can get in serious trouble. You see it coming, you get out of there. Leave it alone. That's the religion thing. I would love to see an announced and pronounced atheist on the Supreme Court. I'm convinced it'll never happen in my lifetime. All these folks, including the senators who have taken an oath to uphold the Constitution forget that in the Constitution, I think it's Article 6, which says there shall be no religious test for public office. Well, forget that. There is a religious test for public office. And I would love to see that dialogue. It comes up in the First Amendment cases. Sometimes it's going to become more and more of an issue, I think, in terms of the tension between the Free Exercise Clause and the Establishment Clause. As to which is more predominant, I don't know. The racial thing versus the religious thing. But discrimination is there. Clearly, it's a very different kind of history. Neither one of the histories are ones that the country can be very proud of. But I really can't answer the question much beyond that. So I don't know.
I think we're about out of time. I think we've heard a diverse and interesting and enriching discussion on diversity, and I want to thank the panelists very much. That was terrific.